Drastic but necessary. That's how the federal government is defending its threat to jail and fine Australians who try to return home from COVID-ravaged India.
Now, it insists that the tough new measures are designed to keep Australians safe, but critics say they are too harsh, and they're accusing the government of abandoning its own citizens at the worst possible time. Well, joining us now is Kim Rubenstein, who is a professor of constitutional and citizenship law at the University of Canberra and the co-director of the 50/50 by 2030 Foundation. Kim, thank you so much for joining us on this Sunday morning. Does the government have the right to deny its own citizen entry back into the country?
So the answer is that there are two frameworks to say no. One is the international law framework, which Australia has already been found to be, there's been an application and an interim measure by the UN Human Rights Committee requesting Australia to bring and facilitate Australians to return home because of the breach of Section 12.4 of the International Covenant on Civil and Political Rights. But with this more recent measure, I think that there's a serious question about its lawfulness under the Biosecurity Act, which is the act under which these penalties and restrictions have been placed. And I can tell you more about that if you'd like.
Yes, sure, please do.
So under that act, the Minister has the power to make determinations in biosecurity emergency scenarios. But it's very clear, and the language of the act, the legislation itself says that the Minister is constrained by looking at whether it's appropriate and adapted. But the other words which draw from the human rights language is that it is no more restrictive than is necessary in the circumstances. And there are very serious questions here about whether this is no more restrictive in the circumstances, particularly when there is that presumption that citizens have a right of return. And we haven't seen, apart from a blanket statement that this is necessary in the circumstances, evidence as to why this is different, for instance, from the situation in Wuhan, for instance, at the very beginning when the emergency was announced and special flights were arranged to assist Australians in an emergency, or how this is significantly different from the situation in the UK when things were at its worst, when Australians were still able to at least try and fit into the travel caps, and the caps themselves, I think, are very questionable. So I think in those circumstances, the government has to do more to justify how it's actually fitting within those legislative bounds, which on its face it does not appear to be doing.
Kim, you wrote a piece in the Saturday paper, and I'm going to quote here you saying, "Alone among Western democracies, Australia does not have a bill or charter of rights, nor does it have any explicit citizenship rights protection." I think many Australians overseas and many Australians here at home would be very surprised to know that.
I think it is really sobering and perplexing, and it's part of a broader package of saying Australia is alone here. We see that the US have similarly put some restrictions on flights coming out of India, but made it very clear it's bringing back its citizens, and not only its citizens, but families and permanent residents. Other countries will always protect its citizens in emergency scenarios. In Israel just a month ago, there was a challenge to similar restrictions on travel bans and exemptions, and the Supreme Court in Israel struck it down as unconstitutional. But as you've just said, and as I've explained, we don't have that explicitly in our Constitution. I do think, however, that there would be arguments to be made that there are implied constitutional protections for citizens, and this would be a scenario where a case could be run to say that the government is overreaching its legislative power under the Biosecurity Act, not only in the terms that I've just explained within the legislation itself, but in underlying constitutional principles about the extent of that power when it comes to restricting citizens in those situations.
Can the government argue that they are doing this or restricting the entry of citizens in order to protect national security?
Absolutely, and in a health measure, that is the context that they're doing this. But in all those legislative frameworks, when the government is using extreme powers, it has to show under human rights principles, but also in the legislation itself, that it's appropriate and adapted, and here, the least restrictive measure. Now, we have a quarantine report that Jane Holton handed down to the government last October saying that emergency quarantine measures should be part of the avenues available to keep both Australians safe here and those Australians coming back. It's not a mutually exclusive scenario. It is possible under the federal government's quarantine concurrent powers with the state to enable citizens to come back safely and to keep Australians safe. Since last September, I've been publicly saying, I think it was in Q&A last September, that the government has a clear and important responsibility to be doing this work to ensure that both Australians abroad and here are kept safe. It has the capacity to do that. It should have been doing that very early on in the piece. There's no question that the pandemic is not going away and that there'll be future emergency scenarios where these quarantine facilities will be needed. This is something that we really must, all voters should be asking of their electors, why hasn't this been done sooner? And why are these Australians being treated in a way where their rights are not being protected, whilst Australians here, health and safety can also be protected at the same time?
Kim, I'm very aware that we are having this discussion in a very safe area here in Australia where the COVID-19 cases are relatively low compared to, the rest of the world. And I am also keeping in mind that we're talking about the legalities here. We're talking about the government's responsibility as well.
Yes.
What, though, can an Australian who is stranded overseas, what can they do to try to come back?
Well, this is a very difficult scenario because this is where government has so much power in the sense that it's acted, and so it's now for the citizenry to respond. Of course, we have our federal court system, and an urgent application could be on the agenda for individuals to make to the court seeking a declaration or some review of the lawfulness of that determination. But that requires a court then to come down with the decision that the government has to act on. I see also that the Human Rights Commission issued a statement yesterday in relation to its serious concerns about the human rights issues by this most recent announcement. Whether the Human Rights Commission can go to the government and implore upon the government to do more to assist its citizens. The Senate COVID Committee is another framework for the opposition to be speaking and calling out to this government that it needs to ensure that it acts with its quarantine powers to and its capacity to bring those Australians back in emergencies as it's done in other emergencies, and to provide facilities in regional Australia. We know we have Howard Springs, and that makeshift areas could be set up quickly. Of course, it wouldn't necessarily be hotel-style environments, but it could be safe environments where those individuals are serviced carefully and that the health protections for them and also the greater community could be established. These are things that really must be done.
Kim Rubenstein, it is so good getting your insight on Weekend Breakfast. Thank you so much for explaining all that to us. We appreciate it.
Thanks, Fauzia. Thanks for your time too.